Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. My name is Dan Balkaran, as you can see on the screen. And I am going to be your employment lawyer for the next 30 minutes or so, answering all your questions about all things employment law. Let's move this over here so you can see that nice weather we're having on the West Coast. As you can see on the screen, my name is Dan Balkaran. I'm an employment lawyer at Samfiru, Tumarkin, LLP. As always, Canada's leading employee-side employment law firm. Okay, so just a bit of housekeeping before we get started. You can reach us if you need to at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Please send in your questions. We had a really good set of questions 2 weeks ago during our last session. Hopefully we keep that rolling today. Okay. Question from Sir. Can someone on severance travel outside the country? Okay, so I think, so if you're terminated, if you're terminated without cause as an employee, you're entitled to notice or pay in lieu of notice. If you're provided working notice, you're still an employee. You're just working through your notice period, generally coming into the office, although sometimes employers structure it in such a way that you don't actually have to do that. If you are not provided working notice and are actually instead provided money, it can come in two forms, or it generally comes in two forms. One is as a lump sum all at once, and another is on salary continuance. So generally speaking, what an employer is going to do is they're going to exchange some form of severance beyond the statutory minimums, although not always, for a signed release. And once that happens, you don't have a claim anymore. Once you sign the release in exchange for money, so you don't have a claim anymore. But the deal is also done. Okay. And so you can do whatever you want. So if you're on a salary continuance, it depends on the nature of, it doesn't depend on anything. Unless you have an obligation under the terms of the deal you struck to look for replacement employment and report that back to the employer, such that the employer can, or your former employer can, deduct your remaining severance owed to the extent or partial extent of your earnings from your new job, then I don't see why there'd be a restriction on your ability to travel. So, but it's hard to answer that question without more specifics. So you may want to talk to an employment lawyer about that. And again, you can reach us if you need to at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Kareem asks, does severance pay include any back pay or unpaid overtime? Okay, so sometimes severance pay is referred to as back pay. So back pay implies that there's a break in employment or a severing of employment, and then you want paid for that period of time that was missed. That is inherently what severance is. But it may be that you're referring to something else. So if you can be more specific about that, Kareem, I might be able to answer that later in this broadcast. Unpaid overtime is an interesting one. So no, you're either going to have a contractual entitlement to overtime in your employment contract, or it's going to be an implied term of your employment contract. And what I mean by that is you work regular overtime and you have done so for several years, okay, in which case you could plausibly argue that the hours of overtime you work are now an implied part of your compensation, okay? Or if you don't have any of that, your right to overtime pay comes from the Employment Standards Act if you're provincially regulated. And so your entitlement to overtime that you've worked but have not received is going to come from one of those places. And that, because of that, that determines what your remedy is going to be. I know this is a very complicated answer. But no, generally speaking, you're either going to have a breach of statute allowing you to claim unpaid overtime, or you're going to have a breach of your contract allowing you to claim unpaid overtime. And why that distinction matters is because I'll just give you BC because that's what I know, and certainly it varies from jurisdiction to jurisdiction. But in BC, if your entitlement to, let's just say you're owed $6,000 in unpaid overtime, if your only legal entitlement to that overtime is from the Employment Standards Act, you can only bring your claim for that overtime through the Employment Standards Branch, and you have a 6-month limitation period from the date of the lack of payment of the overtime, which I think you could plausibly argue was the termination itself, because you had an expectation that they were going to pay you that overtime up to that point. But you have 6 months to file your complaint, after which time you're barred by the expiration of your limitation period from bringing that claim, and you have no claim to that overtime. 6 months is pretty stringent. It's a pretty aggressive limitation period. And just generally speaking, with limitations periods in employment law, there are different ones for different things. So a lawsuit, generally speaking, for wrongful dismissal is going to be 2 years. But if you're federally regulated, unjust dismissal is 90 days. It's very hard cut. Like you gotta make that limitation period. Employment standards in BC, 6 months. I don't know what it is in other jurisdictions. Human rights tends to be a year in every jurisdiction. So you need to move quickly after you've lost your job and talk to an employment lawyer right away. Again, if you want to reach us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. I think that answers the entirety of your question, but just to summarize it, unpaid over. So I don't know what you mean by back pay, because generally speaking, I think you mean severance. But let me know if you mean something specific. And then with other than severance, and then with unpaid overtime, that's not part of your severance. It's a separate legal right that you have that's enforceable either through your statutory right to it or through a contractual claim. I'm not going to identify this person's name because it's unique, and I don't want to breach their anonymity here. So how does punitive damages work, and how do you earn it? A back pay from your employer after you get severance, and what's the difference between examination and cross-examination? And then hold on. His question disappears. Okay. I'll just take punitive damages. So punitive damages are rare. They're not compensatory. So technically speaking, severance is not compensatory either. It's to tide you over until you get a new job. It's a heads up. It's notice, right? It's why they call it a notice period, where you have notice of your termination. You're going to be terminated in 6 months, but you can continue to draw a paycheck, and your employer will give you time off to look for another job. And hopefully you're not unemployed very long, if at all. It's just if the employer chooses to terminate you today, but you're still entitled to 6 months notice, that notice converts into money, which you call severance. So that's what you're entitled to when you lose your job. And I'm not saying you're entitled to 6 months. I'm just saying generally notice. And if it's today, it converts into severance. And then it just depends if you're only entitled to the statutory smaller amount or the much larger, more lucrative common law amount, which can be as much as 24 months of severance. Punitive damages are something that live outside of those pseudo-compensatory damages. They are very rare, and they are where the conduct of the employer is sufficiently egregious, we'll say, that it is deserving of a rebuke by the court. So they tend to be small, $10,000, something like that. And they're exactly what they sound like: punitive damages. They're punishment to the employer for its behavior. So it's rare that you will get those, but certainly in some cases I have seen it, and there's utility sometimes to claiming them, but they're not part of your pseudo compensatory severance structure, if that makes sense. what's the difference between examination and cross-examination? So examination in chief is where you give evidence. Your lawyer is asking you questions, and you're not entitled. The lawyer is not entitled to ask you leading questions. So all of the, we'll say, burden of the quality of the evidence being given comes out of the individual in question who is testifying. Cross-examination is where the opposing party's lawyer asks you questions, and they can ask you leading questions, and through so doing, they're effectively trying to, we'll say, undermine the evidence of that party gave or that individual gave in direct examination. So that's the general synopsis of those two, if you were in a trial situation. Carmen asks, I've terminated without cause. Company said they're going a different direction after hiring someone else to do my same role and responsibilities. I received only 1 week's pay. I'm a single mother. This has left me in a difficult position. What can I do? Well, I mean, so first of all, I'm sorry to hear about your termination. You should talk to an employment lawyer right away. I don't know if they could terminate you only with 1 week of pay. It depends what was in your employment contract. As you can see on the screen, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. So if you were a short service employee, which it sounds like you might have been, and if you signed an employment contract with the employer that limits you to the statutory minimums, it may be that they could terminate you with only 1 week. However, and they can terminate, like, the law is that an employer can terminate you without cause for any reason, barring something that's prohibited by statute. So they can't terminate you because you're away on a medical leave. But often that happens, and then your remedy is damages through the applicable human rights regime. But an employer, generally speaking, can terminate you without a reason, provided they provide you with the required amount of notice or pay in lieu of notice at law. And so the question is, given what your contractual, what your employment contract said, is 1 week sufficient? If it's not, and you're a short service employee, you might be able to get 3-4 months of severance. And so I encourage you to talk to an employment lawyer to find out. But the fact that they said they were going in a different direction and then hired someone else, that has no bearing on what your legal entitlement is, unfortunately. Fred asks, is income from employment prior to termination, is it considered for your severance package? So generally speaking, if you're entitled to common law severance, so it depends what your employment contract says, but if you're entitled to common law severance, then you're entitled to what you would have made during the period of time that your severance period runs. So if you get 6 months of severance, the court's going to ask, what would you have earned over those 6 months? Now, if you're just a straight wage earner, then that's an easy projection. Fred was making $65,000 a year. Therefore, Fred would have made X over 6 months, or 32.5 or whatever it is, and that's what his severance period would be. It gets a lot more complicated if you have if you have variable compensation. And so what I mean by that is a lot of salespeople earn commissions on complicated formulas, and then that compensation can vary with the time of year, or most recently with the pandemic. And so the court in those situations just does its best to try to estimate what the employer would have made during the severance period. And it can take into account, when it makes that estimate, that projection, it can take into account previous history, last 3 to 5 years of variable income earnings. It can take into account what last year you made. So if last year was a down year, that could be a problem. If the court just says that's what we're going to use, it can take into account what's going on in the industry, the economy. and it can take into account actual evidence of what other people earned in that year position during that same period, right? And so it's complicated, but the court just does its best to try to estimate if you have variable compensation. But if you don't, if you're just a straight wage earner, then that's an easy calculation. And that's again for common law severance. If it's statutory severance for, if it's just 8 weeks you're getting under the Employment Standards Act in BC, for example, they're going to take an average of what your last 8 weeks were in terms of pay, and then pay you that out for the 8 weeks. Okay, this other individual I talked to earlier said company fired him after 23 years and he's 57. Yeah, I think just on that alone, I'll call you A, okay? Just on that alone, A, I think that you should talk to an employment lawyer right away. That's a significant amount of service at a significant age, and those things, if you can get into common law severance, mean your claim could be substantially lucrative. So A, you should talk to an employment lawyer immediately. If you want to talk to us, you can do that at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. But I seriously, A, you need to talk to an employment lawyer immediately. Oh, my contact is on the screen. So that's new. If you are in BC, certainly feel free to scan that QR code in the top left corner. Ash asks, if you are let go from a nonprofit, does that change what sort of severance you are owed? No, it doesn't. The law doesn't take into account what kind of business you are working for. I mean, in the wash, do I think a judge might? Yeah. I mean, if you're a mom and pop bakery struggling to make ends meet versus, a multinational, I'm sure the court probably does take that into consideration, but it's not supposed to. And generally the law is, what does your employment contract say? Does it limit you to the statutory minimums? No. You get common law. Okay. Common law, the big severance, and which can be as much as 24 months, generally speaking, 1 month per year of service, and varied by your age, length of service, position, and how long you're unemployed for. So it's not quite a formula, it's an assessment, but those are the factors. So no, it doesn't matter. And certainly I've had files against nonprofits. Shauna started to ask a question, but it didn't quite come through. Shauna, send your question in. I'll try to get to it before the end here if you want to submit it, because I don't think that worked. Sir is back. Sir says, I was a salaried employee and wasn't given working notice, but was let go on the spot. Didn't get an ROE and was pressured to volunteer and agreed. Volunteer for what? I didn't show up as a volunteer. I got 1 month severance anyway. I don't understand what you mean by to volunteer for what. Like, did they offer you another position and you declined? Listen, if your employer says your position is no longer viable, we've ended this particular position in reorganization or whatever, but we have this comparable position that pays you the same or relatively the same, you have an obligation to make reasonable efforts to look for replacement employment. And if your right to severance is not unfettered. Okay, if somebody I'll phrase it this way. So you're not entitled to double compensation. Okay, so if you get terminated on January 1st, and then on January 2nd, you get a new job paying you exactly the same amount, okay, your claim is worth zero because you're not entitled to double dip. You're not entitled to double compensation. Any money you make at the new job is deducted from your severance. And if it's the same amount, then your claim is worth zero. So if somebody makes you a job offer that was reasonably similar in terms of salary, duties, and position, and you don't accept it, your claim is done right there. So if your employer says to you, hey, we are ending this position, but good news, we have this other position for you, and it's substantially similar pay, and you don't take it, there's a strong chance you have no claim. So I don't know what you mean, but sir, I would encourage you to talk to an employment lawyer, and you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, we've got a number of questions, so I'm going to race through these. We had some technical difficulties at the beginning, which delayed our start. So I'm just going to go quickly and try to get to all of you guys here. So Wayne asks, the company has not allowed me to return to work, although the doctor has signed off on it since December during short-term disability. Got an email seeing if I would take a voluntary departure. Should this be the same as severance? Yeah, so I mean, just reading between the lines there, they've replaced you. They don't want you to come back, and they're trying to pay you an amount less than probably what you're owed to have you move on. These are always complicated because, what are your medicals? Do your medicals permit you to return to work, or do you require accommodations? Are your physical or other restrictions central to the core of the job itself? So let's just say you're a pitcher in baseball, a bad example because it's a unionized environment, but you're a pitcher in baseball and now you can't throw. You're probably disabled from working in that job, although not in other jobs within the baseball team. So I think, Wayne, you need to talk to an employment lawyer right away. I'll do all the information at the end in terms of how to get a hold of us. But that's really complicated. But I will say this: if they've already said to you, "Hey, we'd like to do this as a voluntary separation," it looks like they're willing to put some money up to get you out of here. So, and maybe you don't want that. Maybe you just want to go back to work, right? But it seems like there are strategic options open to you. So you need to talk to an employment lawyer right away. I handle stuff like that all the time. If you're in BC, please feel free to give me a shout. But you need to talk to an employment lawyer immediately. Shauna, again, this is her question. So if I do not want the job, the company who bought ours is offering me, even if it's a promotion, can I opt to take severance? Well, it depends, right? So remember what I said earlier, you're in job X and company says job X no longer exists. Well, I think it's more complicated than that. I think new company comes in, buys old company, says we're offering you job Y. Depends on the nature of the purchase, right? So can you say to them, oh, I just want money? Well, if it's a share purchase, they just taking you on lock, stock, and barrel. And if they're changing your position substantially, the question is, do you have a constructive dismissal? Whether or not that change is a constructive dismissal of your employment. However, if it's an asset purchase, technically your old job, your employment is extinguished or terminated, we'll say, unless they continue on in your job as before with no changes, and they don't bring to your attention that your previous length of service has been continued. Sorry, that's specifically in BC. I think the law is largely similar in other places, but this is one area where there may be variation province to province. And so I think that, Shauna, your matter is super complicated based on the paragraph that you just sent in. I don't think you can, I can't answer that question at all without being able to talk to you more fulsomely. You need to talk to an employment lawyer right away. You should do so. Your employer might not even be willing to offer you severance. You need to assess whether or not the job they're offering you is substantially similar to your old one in terms of duties and pay, and if it's even possible for you to reject it without extinguishing your claim. There's a lot going on in what you said, Shauna, and it's very delicate, and I don't want you to take steps that would be very difficult for a lawyer to undo or could be damaging to your bottom line. You don't want to be in a situation where you have no claim and no job. So you should talk to an employment lawyer immediately before you do anything. A is back. How much severance would I be entitled to after 23 years at age 57 from your experience? It depends on your position. It depends on your contract. It depends on a lot of things. Right? So if you had straight common law severance, it could be as much as 23 months, varied by province, less in BC, more in Ontario. But there's just too many variables. You need to talk to an employment lawyer right away and assess your claim. I know I sound like a broken record today, but you really do need to. Shauna's got a lot going on here with the complexity of her matter. You have potentially a lot of value going on in your matter, so that's why you need to take steps to make sure that you preserve that value as best you can. Gabrielle says, I was put on a performance improvement plan 2 years ago for complaining about, I don't know what that acronym means, but retaliation. I was not terminated recently after complaining again. Would that PIP, would that personal improvements evidence help in a lawsuit today? I think you meant you were terminated after complaining. I mean, sure, I mean, I don't know what's in the performance, but I mean, the PIPs are hard, right? Like if they say, Gabrielle needs to do X, Y, and Z better, and this is her last chance, that's hard evidence, right? Of that there's some performance issues. And you say, well, no, I complained about this serious matter, and instead of dealing with it, they gave me a performance improvement plan and then terminated me. Yeah, it can assist in claiming reprisal. The question ultimately is, did they have just cause to terminate your employment and pay you zero? And they might not have paid you zero, but that is still the risk. So I think that both PIPs, actually, so I don't know, there's one PIP, they're going to use that as evidence against you rather than the other way around. I think that, your claim is that they retaliated, but you need to know, I need to know way more specifics. Like, did they pay you? Did they terminate you without cause? What's in your employment contract? It's a complicated assessment. Like I keep saying, unfortunately today, you need to talk to an employment lawyer, right? You absolutely, Gabrielle, need to talk to an employment lawyer right away. Okay, almost done. Shauna says, bank merger about to complete. If I don't want the job offer, even if it's a promotion, can I request severance? And then thanks, I will call a lawyer. Yeah, I mean, if it's a bank issue, then you're going to be federally regulated, which sort of changes the dynamic a bit, makes it a little more complicated. But yeah, no, talk to an employment lawyer right away. I mean, largely what I said before is accurate, but your remedies change if you're federally regulated. Banks are federally regulated, and you've got 90 days to file an unjust dismissal complaint if you've been terminated, which can avail yourself of risk-free remedies, and it's generally a good avenue to take. Last one, Mary. If an employee works online for a company, is it possible to open a claim from another country? So I'll just answer it from an employment lawyer's perspective. So employment law is our regime in Canada. Your rights flow from Canadian jurisprudence and Canadian statute, and it's specific for most of you. It's going to be specific, like 95% of you, specific to each province. Okay, so your rights, some of the law will flow from the Supreme Court of Canada. Most of it will flow either from the Provincial Employment Standards Act and other provincial statutes and various common law decisions in your province. So no, without knowing more, I don't, like, if you're in another country, that's tough too, right? Like, if you're paid in for example, you're paid in BC, but you live in Washington State, no, I think you're probably subject to Washington State employment law, but it depends on what's in your employment contract and what the choice of law clause in your employment contract is. So if it says you're subject to the law of BC, yeah, you might have a claim in BC, even though you're in Washington State. So that's a really complicated conflicts of law question, which, as I keep saying, unfortunately, in this broadcast, is something that you're going to need to talk to an employment lawyer if you have a question about that, because there's no way I can answer that in this forum. So that's it. We answered all your questions today. A lot of you had very specific questions about termination claims that happened to you specifically. And so I encourage all of those people to talk to an employment lawyer right away. You can do that. If you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, so those were great questions today. Thank you for all of them. Please, if you enjoyed today's session, smash the like button for us. We certainly appreciate that. Join us on, I'm going to say Monday, there it is, with Chris Justice, 1:30 p.m. Eastern time. Chris is gonna answer all your questions. Employment law. I will be back, or at least I should be, in this same time slot in 2 weeks. So it's 10:30 a.m. Pacific time on in 2 weeks from now on Friday. So thank you for your great questions. Have a wonderful and safe weekend, and we'll see you next time. Thanks.